Now, if you say that generations of judges, after several years after the Constitution is framed, will be held in bondage, sorry, to what transpired at a particular point of time, and that we are prisoners and we are completely sort of helpless. Ultimately, the core issue that's going to emerge, as we perhaps think, is that what is the value that we attach to many of the core issues, I mean, core fundamental principles which are with our body politics. The first is that we are a democracy. At the core of democracy is the holding of periodical elections. Now, Article 19(1)(a) gives a fundamental right to citizens to express their views by choosing candidates of their choice. The purity and transparency of the elections are intricately intertwined.
Absolutely.
Democracy.
Absolutely.
Now, democracy has been held in Indira Nehru Gandhi to be a part of the basic feature. So these are all not matters which, as you very correctly say, admit of simplistic solutions. But that should not prevent the court from wading through fairly convoluted set of web of issues and finally find light, if there is light.
You're right. Absolutely. You're right.
And find out if there is a way to deal with which is the next important thing. Because you took us through a number of constitutional provisions. The importance, as you very correctly pointed out in one of the paragraphs, will depend on the context. Now, here we are dealing with the context. You must recall that in the Constituent Assembly debates, Dr. Ambedkar, with the usual prescience that he had, he said this is going to be the biggest headache for the future generations, this article. So he foresaw that this is going to happen, and it's happening in our court today, unfortunately or fortunately, whatever way it is.
Yes.
So which is that you have to deal with this issue. So after 70 years of working of our constitution, we have given you the realities on the ground, which is the way in which consecutive governments have appointed chief election commissioners, knowing fully well. See, the whole point is finally what? So finally, each party which comes to power would like to be in power, perpetuate themselves in power. So that is the whole thing. On the one hand, a party which has come to power would like to remain in power. Now the question is how that has got anything to do with the individual fundamental right. That's the issue that you're raising.
You're right.
Correct. Now what it has got to do with is the choice. Ultimately, the fundamental right consists of the real choice of the voter translating into the transformation taking place at the helm of affairs of power.
The little man with the little pencil.
Little man with the little piece of
paper. Churchill famous.
The difference.
Yes.
So we can't be, looking at it very simplistically as, it's a very complex web of relationships.
Yes.
But the value is at the very, very core value. It's at the very root of our constitution, which is having a democratic form of government. Whether we should retain that, enhance it, or whether we should slip into, some other form, finally over a period of time. The example which we gave you was very, very disturbing because we saw from 2015 over a period of 8 years. You have how many chief election commissioners? So this is kind of, pick up somebody, give him a highly truncated office. So you are keeping him under your feet. He is doing your bidding. At least it could be said so. We are not saying that it is.
Right.
But at least it looks so. The same was the position when the UPA was in power. Each government, irrespective of the political color, wants to perpetuate itself. There's nothing wrong.
Right.
That's a right. I want to be in power. But equally, the people of India have a right to say, okay, you may have a right to be in power, but do it by maintaining the purity of the election, fairness of the election. This is, it percolates down to the exercise of the right of the individual, the citizens.
I'm only trying to find that connection. If that is live connection, that the independence of an electoral body spreads out like the spring wheel in all directions, and each one of the wheel, spikes of the wheel makes sense for the total wheel itself. I understand that. But whether it has really happened, like for instance, we no longer have the days of booth capturing.
Pardon?
Booth capturing. We no longer have those days. So the days when the election commission itself, whether the state level or otherwise, was seen to be a compromise in certain election situations. Therefore, in Mohinder Singh's case, this court went into the question of the scope and amplitude of 324. And the rules or instructions the election commission can, within that 324, what it can do. Therefore, it has done several things. Parliament has enacted laws relating to voting rights and then conduct of election, registration of political parties. So many aspects of it have been occupied by rules and legislation. So the Election Commission has set up guidelines and instructions emanating from Article 324. And they virtually in the nature of a positive law, which every electoral officer will have to obey. Then where there is a disobedience, of course, there is an election petition or even sometimes writ court interferes and says that that's why even in Mohinder Singh says if it advances the process of election, a writ court may intervene. If there is any part of the process of election, so recently a lot of said in a case from Goa, the same proposition. Therefore, but ultimately the connection between an individual participating freely and fairly in electoral process, if there is going to be some impediment on that by reason of this, a president having the power of appointment, then one can look into it. If that connection seems to be little tenuous, or it is not demonstrated to be so clear, then certainly the court may sit back and say, is there a need? 25 years or 50 years could be a different question. But even at a 10 years point of time, the need is arisen, Parliament should have intervened. Therefore, the need, that's why the connection between an individual participating in a free and fair election and the electoral body for all practical purposes functions as immune from any political interference. If that is guaranteed, then of course there is court intervention may not be called for. For the importance
the problem. The problem is, it is one thing to say that the Chief Election Commissioner, once he is appointed, he enjoys a tenure of 6 years unless he attains the age of 65 in the midst of that term. Or that his terms of, his conditions of service cannot be varied to its disadvantage after he is appointed. The first provides with 324(5). That is all very good. But there are two limitations on that. The first is the man himself. Who is the man? How do you determine? Because it's a $1 billion question, or perhaps even $1 trillion question.
Yes.
How do you search out and find out the ideal man, the best man? We are not here talking about, like you pointed out, the staff of the Parliament. Here we are talking about somebody who is given a status something close to the Supreme Court judge.
Yes.
So the Supreme Court judge makes it to this post through a very fairly elaborate process we have. Now, all of that is short-circuited by what you have under Article 324, which is the Council of Ministers. Now, if a law were to be provided, we can look at it slightly differently. Supposing the founding fathers did contemplate, there is a law because you will see from the debate that when the last speaker was Dr. Ambedkar, he said, there's a lack of time.
Yes.
And we have to rush through. And then the amendments of Saxena, Professor Saxena was rejected. And Dr. Pandit, he also had various concerns. Both of them he did address, but then finally it is Dr. Ambedkar's amendment, what we have today, that was carried the day. So the concerns which they had, they could not have possibly, seen what is happening today on the ground. They were tall men. Let us admit that. And they were imbued with the values which perhaps do not pervade society today. So many things have changed on the ground. It's a fluid situation, it's an evolving situation.
Absolutely.
If you say that generations of judges, after several years after the Constitution was framed, will be held in bondage, to what transpired at a particular point of time, and that we are prisoners and we are completely sort of helpless. It's a way of looking at it. We can only say that.
I don't think we need to visualize that.
One more thing.
Yes,
CEC records before us, that is the common compilation filed by them. There, the introductory part
Which?
at page 428 onwards.
Compilation.
That is compilation 1, volume 1, common compilation 1.
Yes.
There it would reveal that.
Page number what?
No, 432. 432.
430.
It would indicate that as early as on 9/1/90, the then Prime Minister Sri Vishwanath Pratap Singh thought that the outlined electoral reforms have to be made. And that is at page 432.
Yes, yes.
And one of the most important reforms which he indicated, which are to be made, it is second one. Strengthening of the Election Commission and securing its independence. So as early as in 1990, he thought that these aspects, it requires reforms. That was in 1990. And despite the passage of about, still where were we?
No,
See what is written here at
Yes.
432 on the margin side, outlines of areas of electoral reforms indicated by Prime Minister. Then second one on the right hand side, strengthening of the Election Commission and securing its independence. So such a reform is utmost importance. It is to be made. That was the suggestion made by the then Prime Minister. So that you realize, that is why at the outset also said, you realize that an obligation is there and you will have to take some steps. This was felt long ago, decades ago. Still, the notes and the last part of the note of part 2, there for that, the reasons given there and the last parting part of that note, it says, for the aforesaid reasons and keeping in mind the separation of powers principle, this court will be pleased to decline to interfere in the above petitions. So when you yourself thought that it is required and not having taken anything, whether still the court should remain as a mute spectator.
Yes, I'll try to respond. In the life of a nation, one very important and vital matters. Either the parliament or the executive does not act again uninformed. It must inform itself. And there are a variety of ways it may inform itself, like a planning process of drawing up for urban planning. It must inform itself. For the purpose of informing itself and understanding the aspects where there is a need for executive action or a parliamentary intervention, how does it inform itself? So there are different distinct modes, and the Commission of Enquiries is appointed. So these are methods and means by which the information and the assessment of a situation is gathered by the executive, and then if the executive thinks, yes, this must now go to Parliament, it goes to the Parliament. There can be situations when the executive assesses this information and still either implicitly or otherwise does not either accept or they don't accept, or they don't. In very often, it's a common practice not only in India, I find across the globe. When this kind of information process reaches the executive, how do they respond to it? There is no one set pattern by which the executive responds to an information process. It is conditioned by a wide range of political, social, and other factors. So therefore, the mere fact that information has reached in the domain of the government, probably it's easier to say, yes, what are you doing with it? It says there's an urgency in it. There's an importance involved in what are you doing with it? That question will again become a social and a political and a parliamentary debate. My only concern is that whenever there is an information on any aspect, by way of a report before the executive, will the court say, now, what are you doing with this? The problems involved in this. I'm not saying that the court will
This
not
is not
order
an
it.
information
What? I'll answer.
received.
I know.
This is one of the reasons which ultimately led to the constitution of the committee.
Yeah, I only.
Going by the, what is revealed from page 4.
I'm not trying to resist any resistance.
We are
I'm only trying to say, how do we really look at it? Because after all, it's a dialogue between the court and the officer of the court. So I'm not even trying to say what I close my mind because I already some preconceived ideas. Let me only go on those lines. I'm not doing that. I'm only trying to say that I'm asking questions because of the way I think we get illicit answers, answers which will be in the best interest of administration of justice and progress of law and rule of law, etc. That's how your lordship. So I'm correct on that. Therefore, I ask myself a question: if there is an information, a survey, and a report, so at what point of time, under what circumstances will the court, if it is all his attention drawn to it, and in what framework of a proposition, the court will say that now I think, in my understanding, in our understanding, this ought to be done. That question is a very important question. So there, considerations such as any number of reports, or I find these reports are by and large swap the same language. They are a very general character, strengthening the electoral body. I can understand if there is a specific recommendation made, saying, look here, we have analyzed, for instance, if the government had to look into all these appointments, 8 years to 2 years, 150 days, something which is very wrong with the system, we must look into it. If the commission had gone into it and said it has analyzed it, and said, yes, it doesn't inspire confidence in us that the system is working well, perhaps the president in an appointment process is not effectively advised by the Council of Ministers.